Good evening and welcome to the October webinar for Trafalgar. Thank you very much for joining us this evening. We are all Cape Town based, so it's almost past our bedtime and working time, as you might know. With me today is my colleagues, Corinne Kutsia and Helene Thompson. Corinne is our National Property Management Consultant and Helene Thompson is the Branch Manager for Cape Town. We will be sharing our contact details after the session as well throughout the slides. So you're more than welcome to speak to us if we don't get to your all-important questions today. Just by way of introduction, unfortunately, the erudite Andrew could not join us for the session this evening. Please keep your questions to the Q&A, so you're able to go and access the Q&A right now. At the bottom of your screen, click that, and you can go and ask your questions throughout the session that we're going to be presenting on. Obviously, today we're going to be talking a lot about roles and responsibilities of the trustees, of the managing agent. If you haven't had a look yet, our October newsletter is also now live. You can go and access that. Please go and subscribe to our newsletters. You'll get a free copy each and every single month sent to you by email as well. And this month we all dealt with roles and responsibilities and the importance of the responsibilities that each one of us holds within a complex, within a community scheme. This session will be recorded and it is going to be available for you on Monday through the YouTube channel as well as on our site. If you would like a copy of the slides, please, in the Q&A, you can just go and type your email address for us there, and we'll send you through a copy of the slides as well on Monday. Corinne, if you could skip the slides just quickly to the... Thank you very much. Oh, sorry, the previous slide. Just want to go through those. Thank you so much. Thanks. So today we'll be touching on some legislation. Corinne's going to do that for us. We're going to be working through trustees or the executive managing agent, functions and powers of the body corporate, general duties and duties of the trustees. And then Helene's going to touch on fiduciary duties of the trustees, best practice ideas for trustees, and the roles of the managing agent. If we don't answer your questions throughout the session in the chat, we will do so at the end. And then we'd just like to share some interesting news at Trafalgar with you at the end as well. But once again, thank you for joining us. Corinne, I think you can get going.
Thank you so much, Peter. Let me just go to the correct slide. Okay, so let's start with the boring stuff first, and then we can go to the more interesting. So let's start with legislation. Just for those of you that don't know, we used to have only the Sectional Titles Act 95 of 1986, and then 7 years, yeah, can you believe it, 7 years ago, we got a new act. So basically what they did is they took the Sectional Title Act, ripped out all the management portions of it, left behind the development portions, the registration portions. So we still have the Sectional Titles Act, but they took all the management portions and started a new act called the Sectional Title Schemes Management Act. And yes, it's 7 years old this month. In that act, we have the prescribed management rules and prescribed conduct rules, and I will be touching on some of these as I go through the slides. And then also from the same date, 7 years ago, we also have the CSOS Act, the Community Schemes Ombud Service Act. So all of those acts, 7 years old. We have on our website, I put a link there on our training page. We have all these acts for you available in Word. What makes it nice to have it in Word is that you can actually search a keyword. So if you're looking for something on exclusive use, you can just go to the search function on the Word document and search for exclusive use. So it is available on our website for your ease of use. Okay, so let's look at trustees. The trustees are not just there by chance. They get elected at the general meeting by the members. The members are the owners of sections in the scheme. Trustees are not the body corporate. Sometimes people refer incorrectly to the trustees as the body corporate. I want to be on the body corporate. Body corporate didn't do this. Body corporate is telling me that. the trustees are not the body corporate. The owners, all the members are the body corporate, and they then elect a committee which is called the trustees. The trustees function on behalf of the body corporate, but they are not the body corporate, just to try and emphasize that. Then in terms of the legislation, the body corporate needs to enforce the rules, administer and manage the common property, and they're bound by the sexual title legislation and also the scheme's rules. But the owners can direct the trustees. The owners at a general meeting can place directions and restrictions on the trustees in terms of certain things that are over and above what the Act already says, because the Act already placed some directions and restrictions on the trustees. They can't just do whatever they want. If you have a problem with getting trustees, if nobody wants to be a trustee, since October 2016, there's a new option for such schemes, and that is called the executive managing agent. So executive managing agent term is a bit confusing. It sounds like it is a managing agent, but actually this person takes over the functions and powers of the trustees. So they should have actually called it an executive trustee. I don't know what would have been a better word, but yeah. The executive managing agent is appointed by the owners by special resolution at a general meeting. If nobody wants to be a trustee, you cannot find trustees. The executive managing agent can then still appoint a managing agent to deal with functions that is prescribed in terms of, or not prescribed, that is assigned to the managing agent in terms of a management agreement. But the executive managing agent also cannot do whatever they want. They, in Afrikaans, we have a saying, maak en breek. You can't mark and break like you want. They have to report to the owners as well. And there's a prescribed section in the Act that says what must be in that report and how regularly the executive managing agent will report. But we're not looking at executive managing agent today. We are actually looking at the trustees. So Section 3, 4, and 5 of the Sexual Title Schemes Management Act deals with functions and powers that the body corporate have, certain things that the body corporate must do. In Section 7 of the Act, it states that those functions and powers are going to be performed by the trustees, because obviously, as I said, the body corporate, all owners cannot function, all owners cannot do all these things. That's why there's a committee, the trustees, and the Act then assigns these functions and powers to those trustees. So if we look at Section 3, 4, and 5, couple of things. You have to have an administrative fund. You have to have a reserve fund. Reserve fund new since October 2016, but it's a good thing. It makes us save up for things. It makes us plan. It makes us plan ahead and be proactive instead of just reactive. Also, the owners need to make contributions to these funds. So these are all functions and powers of the body corporate that needs to be performed by the trustees to determine the amounts that the owners must contribute, to raise those contributions, to collect those contributions. We'll get to the role of the managing agent later on in terms of this, but these are all duties of the trustees that they have to perform. It is also important that if the developer reserved a Section 25 right of extension, we're not going to go into detail of that, but that just shortly means that the developer reserved a right to come back and add units to the scheme. Where there's space, build in phases, add some more units. The developer must then also make contributions as a member to the body corporate. And also there must be separate bank accounts. There must be a bank account for the admin fund. There must be a bank account for the reserve fund. All duties of the trustees. Big duty of the trustees, the maintenance of the common property. A lot of people say, my managing agent is not painting my complex. It's not your managing agent's duty to paint the complex. It's the duty of the trustees in terms of maintenance of the common property. Insurance, big thing as well. The buildings and common property needs to be properly insured. In order to do that, you have to have a valuation done every 3 years. You have to pay your insurance premiums, have to deal with insurance claims as they come along. So that goes hand in hand with maintenance of the common property. Another function is to appoint agents and employees. The Act does not prescribe that a managing agent must be appointed, but I can tell you many schemes out there feel that it's better to assign and appoint a managing agent. because they have the proper knowledge, they have experience, they can assist the trustees. Also to appoint employees, that's another function and power that the body corporate has. The body corporate can buy and sell units when it's essential for the proper fulfillment of its duties. You only need a special resolution for that. The body corporate can purchase, hire, acquire movable property as and where needed. Like, for instance, a generator, that would be seen as movable property. To establish and maintain lawns, gardens, recreational facilities. That is a power. It's not a must that it must be done, but it's a power that the body corporate had that it can do. The body corporate can borrow money, take out a loan, for instance, if you want to paint the complex and you don't have enough funds, it is possible to take out a loan, and for that you would need a special resolution. And then when it comes to that loan, if to secure the repayment of that loan, it is possible to mortgage any property owned by the body corporate. To invest money, the body corporate has that function as well. To provide for services, including the power to rent a portion of the common property. So we're not going to go into the detail of leasing of common property. Could be different scenarios, could be leased to an owner or occupier, could be leased to a third party, but the body corporate has that power. A big one, the enforcement of the rules. So every scheme has got rules. You've got conduct rules, you've got management rules. You can either work on the prescribed rules of the Act, or you can have customized your rules. Conduct rules customized by special resolution by the owners, management rules customized by unanimous resolution of the owners. But every scheme has rules. No scheme can say we don't have rules. If you don't have customized rules, you work on the prescribed rules of the Act. Management administration of the common property, we talked about that. Then in section 5, there's a couple of additional powers. The body corporate has the right to alienate any part of the common property, to enter into a long-term lease or a third-party lease. This would be your cell phone tower, for instance, that want to rent roof space. For that, you would need a unanimous resolution. And then to alienate, exercise, or cede a right of extension of the scheme, that right that I spoke about earlier with regards to addition of sections, if the developer is no longer around, this right cedes into the body corporate, then it is possible with the written consent of all owners as well as all bondholders to alienate, exercise, or cede this right to another person to come back and add some sections if there's space, obviously. Then you'll see, just want to mention, you'll see a unanimous resolution, this special resolution, that written consent, this sometimes ordinary resolution, whatever. To not get confused on the types of resolutions, we have an easy guide to resolutions that you can just request and we can email it to you that explains the different types of resolutions, how to achieve them. I'm not going to go into that detail tonight, but you can see there's some other functions and powers where for this you need a unanimous resolution, for that you need a special resolution. The body corporate can purchase land. The body corporate can give owners exclusive use rights in terms of the plans. It can also give exclusive use rights in terms of the rules. It can cancel those exclusive use rights, can create servitudes, or approve an extension of a section. There's just different rules or resolutions that's needed for these different powers. And then we go to the management rules, the prescribed management rules. In prescribed management rule 9, the Act looks specifically at trustees and says a couple of things. The Act says trustees must meet. It doesn't say how regularly they must meet. It doesn't say they must meet every month, every week, every day, once a year, twice a year. It just says that they must meet. So obviously we suggest that they regularly meet, and not just once a year, but regularly meet, discuss the issues, take some resolutions, come up with some ideas, but the trustees must meet. There's different resolutions, as I said, body corporate resolutions that we have our guide on. There's also trustee resolutions. So the trustees cannot, one trustee or the chairperson cannot just make things happen and do things on his or her own. If it has to be decided by a trustee resolution, if it's not prescribed to be an ordinary, special, or unanimous resolution by the body corporate, then it would be a trustee resolution, and that means the majority of the trustees need to agree, not just one or two trustees that decide to do something. there must be a majority decision. The trustees can also appoint an agent or employee, as we said earlier. It's also stipulated here in the management rules, and here it goes further on to say there must be a written signed contract. Yes, we get verbal contract, but always better to have a written signed contract with the managing agent or the employee, so that it clearly stipulates what can I expect of you, what can you expect of me, what's the terms and conditions, like a service level agreement, to call it that. And then also it stipulates that the trustees must compile minutes of every trustee meeting and every general meeting and distribute these minutes within 7 days after the meeting. Just to go back to the CSOS Act, as I mentioned before, this Act also came into being on the 7th of October 2016, 7 years old now. It also touches on trustees. It doesn't say trustees specifically, but it says into the definition of a scheme executive, it includes a trustee. So if the Act talks about a scheme executive, they're talking about trustees of sectional title schemes. They're talking about directors of homeowners associations, trustees of common law homeowners associations. And the CSOS Act stipulates a couple of things with regards to these scheme executives. The one being that him or her, is my English correct, must educate themselves with regards to a community scheme, must be educated, must know the scheme, must know its affairs and activities, must know the legislation, must know the governance documents. Now, the governance documents, that would be the rules that I was referring to earlier. When a decision must be taken, that person must obtain sufficient information and advice. Go out, consult with the experts before you can make a conscientious and informed decisions. Don't just make a decision because you feel like you like that person. Make an informed decision. In terms of meetings and attending meetings, unless excused by the chairperson, all trustees must attend all trustee meetings, must attend the community scheme's annual general meeting, unless excused by the chairperson, as I said. And then important, have an active and independent opinion. Don't just be swayed by what the majority says. Have your own opinion. And as I said, make it an informed opinion. And then also the trustees must exercise due diligence in relation to any business and must prepare for meetings and not just attend meetings. That is it from my side. I'm going to hand over to my colleague Helene now. She's going to go into a little bit more detail with regards to the fiduciary duty of trustees.
Good afternoon, everyone. The fiduciary duty of trustees with the body corporate is probably one of the most important duties of the trustees, and it is very often misunderstood. Members of a sectional title scheme feel that they can contribute towards the management and day-to-day operations, and by doing so, protect and improve their own investment. And in line with this perception, they put themselves forward for nomination as trustees and then proceed to either offer services, professional input, or something of that nature to the body corporate. Inherently, that's not wrong. However, the question of fiduciary duty does come into play and needs to be considered. Fiduciary duty is a duty of trust. Trustees stand in a fiduciary relationship with the scheme, whereas managing agents stand in a contractual relationship while still being supervised by the trustees. What the legislation provides for the fiduciary duty of trustees is that, firstly, they have to act honestly and in good faith. Any powers they exercise must be to the benefit of the body corporate and the interest of the body corporate. They need to avoid any material conflict of interest, and that pertains to both direct or indirect economic benefit. And in the event of any material interest they might have, this needs to be disclosed to the trustees. If you could move to the next slide for me, please. Then also they need to take into account that they may then not take part in any decision-making process and may not even be present when the matter is considered. In terms of the legislation prior to the 7th of October 2016, trustees were indemnified against their actions unless gross negligence, which is open to interpretation and sometimes very difficult to prove, can be proven. Under the new legislation, trustees can now be held liable even if they did not act in bad faith or grossly negligently. So what does that mean? It means that trustees can be held liable for any loss suffered by a scheme or any economic benefit received by that trustee. In terms of Prescribed Management Rule 8.4, the legislation does provide that trustees need to be indemnified against all costs, losses, and expenses arising as a result of any official act. But it goes further to clarify that the official act is not in breach of the trustee's fiduciary obligations. It's therefore very important that the trustees keep in mind their fiduciary duty towards the scheme at all times. You can go to the next slide for me, please, Corinne. Then I'd also like to take this opportunity to provide trustees with some best practice tips, which you could make use of. Firstly, the allocation of portfolios. Having a specific trustee taking charge of a specific portfolio will assist in reducing correspondence volumes, which all trustees need to be included in. Having a more focused approach towards resolving outstanding matters. Trustees could also provide a mandate to the relevant portfolio director on what powers they may exercise on behalf of the scheme during the discharge of their functions, more specifically in respect to their portfolio. But it is very, very important that the mandate should be clearly worded. Secondly, regular meetings, whether they be online, telephonic, or in-person meetings. The fact is that a number of trustees are bogged down with volumes of correspondence, some of which could easily be eliminated with more regular, brief, and focused meetings. Reviewing of monthly management reporting. It's crucial that trustees review the reporting received and raise any concerns that they may have. Most managing agents provide some type of reporting. The reporting provided by us contains details, for example, that will in most cases allow trustees to identify a number of operational concerns and not just merely financial reporting. To name but a few, you would be able to pick up dramatic increases in expenses, items where the budget has been overspent, even potential liability for the scheme in regards to scheme staff, which might also have a financial impact should the employment agreement of the relevant staff member come to an end. Recurring maintenance expenses could also be monitored to pick up trends, to better plan for alternative measures that you could possibly put in place to limit or prevent even future spending. Then in terms of budgeting should ideally be done in the last few months of each financial year for the following year, the coming year. This allows for the most accurate year-to-date figures to be taken into consideration, but also to allow for any potential increases to be implemented sooner rather than later. The legislation allows for a maximum of 10% from the start of the financial year, but if this is not applied, you have to wait until the conclusion of the AGM to implement an approved increase, which then results in a higher percentage increase month on month in order to achieve the same income over a 12-month period. Just as an example, if your current monthly levies are 10,000 Rand a month, meaning 120K per year, and you need to collect 150K over a 12-month period for the new year, increasing the levies in the first month of the financial year would result in a 25% increase. Whereas if you had to wait for the AGM to be held, which is usually around the fourth month of the financial year, you'd only have 8 months left to collect your income, meaning you would collect your 10K per month, 40K in the first 4 months, leaving you with 110K to collect over the remaining 8 months, which results in a monthly levy of 13K7, which effectively means that you would require a 37.5% increase as opposed to the 25% increase. So, as I say, rather sooner than later. Financial management should be monitored regularly in order for any remedial actions to be taken if necessary during the financial year, because while your budget is approved annually, the budget is an estimate. As we all know, emergencies do happen, and this could severely impact your financial status as a scheme. Proper financial management would allow you to take steps faster to reduce the financial impact overall. Understanding, applying, and project managing a recommended governance checklist. A checklist should be put in place containing all the required deadlines for governance matters, and the trustees need to familiarize themselves with what is required to achieve completion of those items, when they should start to plan or start to consider those items is a good item to add to that planning. This will also guide trustees who are allocated with specific portfolios in terms of their requirements. And then the importance of signing and updating resolutions. Resolutions will be required for various matters. In our opinion, we suggest at least the following resolutions be in place and reviewed annually. In terms of the levy resolution, these resolutions are required in terms of the legislation in order to legally raise levies, but they become crucial when having to enforce the collection of arrear levies, because they have to be submitted to the courts or to the ombud when taking actions to collect those levies. The interest resolution, similar to the levy resolution, this is also required to raise interest. It determines the interest rate to be applied to arrear levies, as well as needs to be submitted with taking any action in recovering arrear levies. Then we come to the handover resolution. This resolution provides a mandate to your managing agent to act on your behalf in the collection of arrear levies. As it is a mandate, this then reduces the requirement for trustees to be involved daily in regards to discussions surrounding arrangements, legal actions, appointments of attorneys, and so forth. And then last but not least on our list of resolutions, we would recommend a recurring payment resolution. The resolution also reduces the additional volumes that trustees would otherwise have to deal with in terms of approval of invoices, because it's a mandate allowing processing of those recurring invoices. It could also provide for a mandate to proceed with payments to suppliers you use regularly up to a specific limit, such as the purchase of cleaning materials, reimbursements of petty cash, and so forth. Right? You could move to the next slide, please. There we go. All right, so now by now, some of you are probably wondering, if we have to do all that, what's the managing agent doing? Well, let's take your children, for example. You are ultimately responsible for their education, but I'm sure most of you aren't the teacher standing in front of the class. What managing agents do can be found simply in the definition. Agent is a person who acts on behalf of another person or a group. We manage the functions and instructions given to us by the clients in line with our contractual relationship or any additional mandates that have been given by the trustees or by the members. These are a few, but not an exhaustive list of functions what most managing agents will include in their scope of service. The financial operations of the scheme, while not the only function, play the biggest part in the day-to-day functions of the managing agent. Billing and debt collections might seem a small part of this. However, when issuing accounts to members, many background processes and checks need to be in place. Firstly, ensuring the transfer of any property within the scheme is processed correctly, with the correct consents, calculation of figures, member contact details captured, capturing of contributions due by the member, and so forth, to ensure that the database of members and corresponding detail is accurate. This is monitored usually on a daily basis, without which it would not be possible to issue accurate levy accounts to the correct members on a recurring basis. Coming to debt collection is a very important focus area for most managing agents overall, because we know without cash in the bank, we can't pay the expenses for the scheme, which results in even more admin and intensive planning going forward. Various actions are taken by the managing agent when focusing on debt collection, effective and regular communication with members in arrears being a crucial part of this, and high focus during the initial stages of arrears results in faster positive results than when an account eventually needs to be handed over to the attorneys to follow the legal collections process. When an account is, however, handed over to the attorney to proceed with the collections, there's also regular interaction between the debt collector from the managing agent and the attorney in order to monitor the progress, to assist with any additional instructions. And of course, all actions have to be noted in order to form part of the reporting presented to the trustees. And the managing agent will also then provide guidance to the trustees on any decisions they may need to make during this process. The debt collector will also be involved in communication with members who have any disputes on their accounts for various reasons, assisting members with different payment options available, referring them to the correct person to assist the owner, depending on what type of query they've raised. So there is a lot of background processes going into just that one item. In terms of administration of bank accounts and payments of expenses, let's first have a look at the administration of bank accounts. The managing agent will manage the bank accounts and ensure that proper reporting is provided to the trustees. They'll ensure that funds are available by means of transfers to and from investment accounts when it's required to fund expenses. They'll provide guidance to trustees on when it might be best to consider investing portions of those reserves so you can boost your interest rates. They'll monitor your cash flow requirements where needed, ensure allocation of payments by members to their levy accounts, and also bearing in mind that the legislation requires 2 sets of books to be held, one for the admin and one for the reserve account. In terms of payment of expenses, also certain processes are followed and has various background work taking place. Some managing agents may treat these processes a bit differently, but some of these processes include verifying supplier bank details, double-checking validity of invoices in terms of SARS requirements, planning for payment dates as needed, following up on recurring invoices not received from suppliers, obtaining approval from trustees for the payment, or where a mandate or resolution is in place, processing those payments, and then also assisting with inquiries from suppliers on payment allocations. Then we move over to meetings. Having been presented with the duties of trustees, I'm sure we can all agree that in order for trustees to function efficiently, they need to be armed with comprehensive information when making decisions. Communication of this information may take various forms: daily discussions, emails, chats with your portfolio manager. However, a lot of this communication is transmitted to trustees during meetings. And in order to do this, proper preparation needs to be done for the meeting. The managing agent also needs to take into consideration the legal requirements for meetings, the preparation of any supporting documents, the quorum requirements for various meetings, depending on the decisions taken, the voting requirements and how it's going to be managed during the meeting, whether it's required to calculate those votes by PQ and ensure that they are prepared to manage it during the meeting. This requires preparation of data prior to the meeting as well, so it's not only work being put in during the meeting. And then, of course, we have the minutes of the meeting, which is also in most cases done by the managing agent, and the action items to be addressed after the meeting, and the list goes on. On a more ad hoc basis, which could be either daily, monthly, or in some cases few and far between, we have the administration of enforcement of conduct rules. In this case, an instruction would usually be sent to the managing agent to issue a letter of non-compliance to an owner for a specific contravention. The communication then needs to be drafted and sent to the relevant member. They need to assist in attempting to resolve any dispute which may arise as a result of that letter. In some cases, penalties might be required to be debited to the member's account, which then needs to be attended to as well. In other cases, the contravention, if not resolved, may need to be escalated in the form of a dispute to be lodged with CSOS, in which case proper preparation of the application also needs to be done to ensure that the scheme has the best possible case to put forward. In some cases, the trustees do deal with these applications themselves because there is usually a cost implication for resources and time allocated to these applications if either a professional or a managing agent is attending to it. In terms of insurance, the managing agent's part in insurance for the scheme is to assist with sourcing quotations for insurance, sourcing proposals for the valuations required every 3 years, as Corinne mentioned earlier, ensuring monthly payments of the insurance premium, arranging for recovery of additional insurance premiums where there are members who've increased their replacement values, assisting in insurance claims that need to be submitted for consideration, facilitating attendance or access in some instances on site for assessors and contractors. But important to note that the managing agent is not usually qualified to provide advice on insurance matters or insurance cover, and would usually refer any inquiries for that type of advice to the insurance brokers for assistance. Then we come to maintenance. So this is the one portion of the scope of the role of the managing agent to which members in general have sight of, and therefore a lot of members would usually base their perception of the service level of the managing agent on this item. However, the role of the managing agent in regards to maintenance is to fulfill instructions received from the trustees. They could be provided with mandates on how to address certain maintenance items reported, like recurring maintenance items that might pop up. They might be provided with specific suppliers which the scheme would like to make use of. They issue requests to the suppliers based on the information they have at hand, such as the specifications provided. They regularly follow up for outstanding quotations, invoices for work done, assessing quotations received to ascertain whether you're able to compare apples with apples, and then, of course, communicating with the trustees for the approval of the quotations. Communication with owner where maintenance possibly affecting a section is reported. At the outset, trying to ascertain where the cause of the problem is originating from, which could be either common property or possibly from within the section. And then while attempting to confirm at the outset, you can also then attempt to confirm who would be responsible for the ultimate cost. The managing agent will also, on request, obtain proposals and quotations from suppliers to draft and review the 10-year maintenance plans on behalf of the BC. Just to bear in mind that the drafting of these plans requires certain skills and knowledge that the everyday community scheme manager does not necessarily have. And then assistance with employees. The managing agent's role in this regard is to ensure that advice is provided to trustees regarding employment of staff. Trustees may want the assistance of the managing agent in the recruitment process for staff. The managing agent is also in a position to assist with drafting the paperwork required to add staff to payroll. Once staff are employed, the managing agent would arrange for the relevant salaries to be paid on due date, managing of leave of the staff on receipt of approved leave applications, ensuring compliance with various legislative requirements such as income tax, UIF, workman's comp registrations, payments, and provide advice to trustees in regards to actions that might need to be taken in the event where the scheme does not comply with the relevant legislation. And then also to just assist with advice on applicable labor laws where necessary. And in some cases, potentially even process or chair hearings for employees on behalf of the body corporate. Then we come to the budgets and audits. The managing agent would usually draft the budget annually for presentation to the trustees. And in doing this, they would take into consideration prior budgets as well as actual expenditure, renewal dates and increased dates of specific expenses, such as contractual obligations, potential changes of suppliers, if they are aware of it, and costing thereof, they would take that into account. And then the requirements of the reserves are also considered. The budget would then be presented to the trustees for consideration, and the relevant processes would take place to approve the budget. In regards to the audits, while it is the members that appoint an auditor, the managing agent would usually obtain quotations on behalf of the scheme for auditors. And in terms of the audit, the managing agent will prepare the audit file for the auditors, ensure that they have access to all the documentation required, submit the audit file to the auditors after the financial year end of the scheme, and would then also assist with any queries which might arise during the audit process. Then the advisory role of the managing agent. While managing agents are well versed in terms of the Sectional Title Schemes Management Act and the Sectional Titles Act, as well as the Community Scheme Ombud Service Act, there is a lot of other legislation that might also be applicable to sectional title schemes, such as municipal bylaws, occupational health and safety, building regulations, and the list goes on. A managing agent, to a certain extent, is expected to be well versed in all the relevant legislation, making them a jack of all trades, so to speak, which is not always the case. The role of a managing agent in terms of any advice given to trustees is to ensure that they provide the most comprehensive advice possible, and in doing so, also in many instances, they need to do a lot of research to be able to ensure that they're providing accurate advice. As with most legislation, interpretation is also sometimes unclear and needs to be considered. So while a managing agent will provide advice as far as possible, there are times when they might suggest that quotations rather be obtained from professionals dealing in that specific industry or with that particular legislation in order to provide better advice. And then the last item is training. The transfer of knowledge from one person to another is what will allow members of schemes to more efficiently manage their schemes. The requirements, the protection of your assets, it's therefore paramount importance that training is done. And while the role of the managing agent does not necessarily have this as a fixed requirement, we do believe that this, in essence, is what will improve the industry of property management as a whole. That brings me to the end of my portion this evening. Back to you, Peter.
Thank you very much, Celine. Much appreciated. The Q&As have actually been flying. So, Lean, I'm actually going to ask you to come back on if you don't mind. And together with Corinne, if we can just work through a couple of these questions. We're going to keep around about 10 to 15. I do see we're pretty early. We've got 20 minutes left. So we'll do the end portions after we've done the Q&A. So I'm going to try and quick fire these. I'm not going to point out who needs to answer them. I'm sure you both can do so. First one from Envoy. The managing agent did not organize the AGM as expected. What do we do as the body corporate or the trustees?
Can I answer that one, please? It is a typical experience that we get. It is not the managing agent's duty to arrange the AGM. They only do it on instruction from the trustees. So the trustees can call a meeting. They can instruct the managing agent to call a meeting on their behalf. The owners, if they get backing from at least 25% of other owners in terms of PQs, can ask the trustees to arrange a meeting. But it is not the managing agent's duty to arrange an AGM.
Thank you very much. Second one, our managing agent refuses to provide documentation, for example, bank statements, contracts, invoices, and they expect us to drive to the office and pay a percentage fee. I'm not going to say how much, thousands of rands, for copies of each page. Should they provide this documentation? Should it be free?
I'll come in on that one. So
Okay.
yes, in terms of documentation, the legislation does specify that members have access to the records of the body corporate. However, they do mention the inspection of those records, and they do mention the possibility that there might be costs involved during the inspection of those records. If they are refusing to provide it to you and you have followed the necessary internal remedies like making an appointment, going to see them, working through those documents, then yes, as a member, you have the right to lodge a dispute with CSOS, and you can then apply for those documents to be provided to you.
Legislation isn't clear on whether trustees can be compensated for their services. Can they be compensated?
Yes, it is actually. Don't ask me now quickly the portion of the Act to quote for you. But the Act does make provision for trustees to be compensated. It is called an honorarium. So you need a resolution to be passed. It depends on if the trustee is an owner or not an owner. So if the trustee is an owner, then it needs to be, now I'm going to lie. Helene, can you remember what it is when it's an owner and when it's a non-owner?
Oh, goodness. No,
if I can ask that, yeah.
Not offhand. I do.
I'm drawing a blank. I'm drawing a blank. So if you can please email me afterwards, our contact details are on the screen. Then I can send you the exact portion of the Act. But yes,
we have to go and do our research on the advice.
Yeah, no, the Act definitely provides for compensation to trustees. And obviously, if you have paid any expenses on behalf of body corporate, you can claim back those specific expenses as well. But compensation, yes, it is allowed. Just email me. I'll send you the correct portions of the Act.
Thank you very much. Helene, I'm going to go for two for you. What are some of the portfolios that are recommended as best practice?
I think in terms of best practice, you need to look at it from a viewpoint, is it financial or operational? So you would always want someone having your maintenance in hand, your security in hand in terms of operational items, enforcement of rules, communication to members is a very good one. And then also, of course, finance. Depending on the size of the scheme, you might want to allocate more than one to finance. You might want to have one looking at your variances or your overspend or underspend on budgets or your projects, as well as one specifically looking at arrears if you have a high amount of arrears and there's a lot of input required there. The more hands-on trustees are in terms of portfolios, the more efficiently they can manage it, and actually where they are also not being overloaded as trustees.
And then also, please just repeat what you mentioned regarding the 10% increases.
So the legislation does provide that the trustees are allowed to increase by a maximum of 10%, but they're only allowed to do so from the start of the financial year. So if they don't do it at the start of the financial year, they have to wait until after the AGM when the budget is approved by the members. So that takes that power away from them, but then they also result in higher increases because they have a shorter period to collect it.
Thank you. Corinne, because you were part of the CSOS discussion, I'm going to ask you, what can a person do if they're not happy with the trustees and what they're doing with their fiduciary duties? Or what can a person do at the complex?
Okay, so first of all, CSOS always says try to resolve it internally. So first option, try to resolve it internally. Call a meeting with the trustees, discuss your concerns with them. Maybe it is only one trustee that you've got a problem with. So call a meeting with all the trustees. Make them aware of the problems. Discuss it with them. If that doesn't help, you have another option before you have to go to CSOS or take legal action. You can get the other owners to back you. If you get at least 25% of the owners to back you in terms of participation quota, you can request a meeting, remove those trustees. The owners, your hands are not tied. The trustees are elected by the owners at a general meeting. They can be removed by the owners at a general meeting. But if all else fails, yes, you can go to CSOS, very cheap and easy because there's no fee, or you can take legal action if it's a complicated matter.
Just to remind our viewers this evening, the previous webinar that we did was actually with CSOS. And if you want more information on CSOS processes, the dispute resolution process, what Section 39 actually allows you to do, what you can take to CSOS, go and have a look at that. It was on the previous webinar. Helene, is there a list of resolutions that trustees can use?
There are, in terms of the legislation, like we mentioned, reference to specific decisions that the trustees have to make. In terms of raising levies, they have to resolve when and how it's payable. In terms of the interest rates, that has to be decided on. But when you look at the word resolution, what actually is it? It is the decision of the trustees being put down in paper. When you're looking at a resolution, are you looking at what type of, are you looking at the type of resolution where they're mandating someone else to do something? That's also a resolution. It could go as far as to say, we want a telecom rental contract or something to be signed for the gate at the complex, and we are mandating these two trustees to sign that contract on our behalf. So I think in terms of resolutions, there isn't an exhaustive list of resolutions. We can provide a list of the major resolutions that we have available to us, that we make use of on a day-to-day basis. And as we've explained, a number of them have good backing and good reasoning behind it. It just makes the lives of the trustees and of the managing agent much easier.
I'm going to quickly just answer Andy on one of his questions. What can you, or how much can you rely on a managing agent for free run-of-the-mill legal advice? It depends on the managing agent. At Trafalgar, we obviously work with a number of consultancies external to Trafalgar, the advisory as well as TVDM. But for run-of-the-mill, Corinne or myself is available if you need quick answers to any questions relating to community schemes or any basically of our services, residential, commercial sales, etc. Corinne, I'm going to direct this one to you. If a managing agent refuses to follow arrears procedures unless the body corporate appoints an associated debt collection company, is that usual in the industry?
Not sure I understand the question. So
if the managing agent sort of refuses to handle the arrears themselves and wants a third party to collect, is that usual or sort of unusual?
Yeah, it's a bit unusual in my mind because as part of our standard management agreement, we deal with debt collection up to a certain stage. But I know there are managing agents. I'm not saying it's not possible. There are managing agents that don't want to register as debt collectors with the Debt Collection Council, and they would then not deal with debt collections, and then it would need to be outsourced. So it is possible, but it's definitely not standard.
I'm just going to throw this one up in the ether. Is it compulsory to have two trustees approve all invoices if a quote was approved? In terms of the act, obviously two trustees need to sign documentation. So is it compulsory to do so?
Yeah, so if the quote was already approved by a majority of the trustees, then you don't need to approve again, because that would be like double approving. But in terms of signing documents, the Act does prescribe that all documents to be binding must be signed by at least two trustees. So if the trustees by majority approve the quote and you get to the 2 trustees to sign the quote, that would cover as approval for the invoice as well. But we always check first before we pay the invoice. We don't just say because you've approved the quote, we'll just randomly pay the invoice, because you have to be happy with the work that was done. But yeah, don't need to be signed again if it was already approved on the quote.
Excellent, thank you. Let's quickly head into chairpersons, the functions of a chairperson. Is there restrictions on how long a person can serve as a trustee or a chairperson?
No. What is interesting, just like a fun fact, in terms of the Sectional Title Schemes Management Act, the Act does not even mention the chairperson. It is only in the management rules that we find this body of a person. And also the chairperson have no extra rights that any other trustee. They have the same rights as the other trustees. The only right they have or power they have over and above other trustees is when there's a deadlock. And that is only at a trustee meeting. When a decision has to be taken and there's a deadlock in the trustees, then the chairperson will have a casting vote. But that is only at a trustee meeting, only if there's a deadlock. Chairperson, there's the Act specifies in terms of chairing the meeting, certain things that you have to do as the chairperson of that meeting. But that's really only the places where the chairperson is sort of like mentioned over and above another trustee. There's no time limit unless the owners, by directions or restrictions to the trustees, say that you're not allowed to be a trustee in our scheme for longer than 3 years. But if you don't want the person to be a trustee, just don't elect that person. But the Act does not prescribe a certain length of period for a chairperson or a trustee.
Thank you, Helene. Can a managing agent choose their own auditors?
So I think in terms of that, I'm assuming that the participants is wondering whether the managing agent can select the auditors for the body corporate. And I think it's very clear the legislation provides that it's a decision to be taken by the members in a general meeting. And we very often in our industry find that the members want to mandate the trustees to elect an auditor. The managing agent might be getting the quotations for the auditors, but the managing agent definitely cannot appoint those auditors. We do not have the mandate to do that. And in our advice, it would be better for the members to not give that mandate to the trustees and reconsider that appointment. And the reason why I say so is because while the managing agent is processing transactions, those auditors are actually auditing the transactions approved by the trustees. So they basically, if they're appointing their own auditor, they're appointing the auditor that is auditing them.
Quickly, just one on cost, perhaps, Helene, because you work and are the branch manager of the Cape Town branch. What is the sort of typical cost to appointing a managing agency? I know it's very territorial based at the end of the day as well.
Is a typical cost to employing a managing agent? Yeah, it is very, very area based. There is a lot of research done in the industry by the relevant groups like your NAMAs and so on. In terms of most managing agents, they would have a fixed fee to offset fixed costs. Your portfolio managers can deal with a certain amount of schemes. Your support staff can deal with a certain amount of schemes. So there are certain overhead costs that would be taken into account. And then depending, of course, on the size of the scheme, they might range. Your management fee per unit might range from about, I would say, 80 to, I think the highest one I've seen this year is 172 Rand per unit here in Cape Town, and that's for a large scheme. Minimum fees on average is usually between about 3 and 5.5 per month.
Excellent, thank you. I'll just quickly do a POPI related question for Frank. In POPI and the Sectional Title Schemes Management Act have quite an interesting, they fit together interestingly, let's say that. It's very difficult because there's a lot of gray areas within the piece of legislation as well. But a managing agent cannot refuse to provide information to a board or to the trustees. Inherently, they are the custodians of the information and they're required to have it to follow debt collection procedure. Okay. So how does one deal with trustees who disregard the conduct rules, restrictions placed on them by owners, and they don't stick to the budget? I think it's a very similar question. Let's go with that one.
Yeah, it is, like I said before, if you're not happy with the trustees, trustees are elected by the owners at a general meeting. They can be removed by the owners at a general meeting. So get your 25% backing from owners in terms of PQs, request a meeting. You must specify that it's for the removal of the trustees, and then you can remove those trustees, elect the trustees that you want.
Gillian, the managing agent's calendar is booked up, so the AGM needs to get deferred. Is this okay? Surely the AGM is important and needs to happen in a certain window.
So the legislation does not provide that the managing agent even needs to attend the AGM. In terms of facilitation of the meeting and actually managing the meeting and doing the minutes, it is usually preferred by members and by trustees that the managing agent attend the AGM. But your AGM is a statutory meeting with statutory agenda items. There isn't a lot of back and forth in terms of those specific items. Those items don't very often change. And I would say in our realm, in our company, we have multiple community schemes managers. There should be no reason why one cannot attend another's portfolio manager's AGM to assist in facilitation. I think the only reason why the trustees might select to defer an AGM for a later date if the community scheme manager is potentially not available is because they are heavily reliant on that community scheme manager to be able to provide responses to the members, which, as we've done or addressed quite fully in this evening's session, is actually the responsibility of the trustees.
Excellent. And I think we're just going to pick a last one. I apologize if we didn't get your questions, but we will do so. What is the required experience or qualification for trustees?
That, unfortunately, is a big fat nothing. There is nothing prescribed in the Act with regards to qualifications and degrees and courses and anything that the trustees may have. So absolutely anybody can be a trustee. So what we do from our side is on our website, I'll show you the link just now. We have a training page where we offer free courses. We even have other managing agents do our trustee training course. We've got a big 7-module course for trustees, specifically sectional title trustees. We have one for homeowners associations as well. There's one for caretakers as well. But the big one is our sectional title trustee training. It's free of charge. You do it in your own time. So yeah, it's recommended. It is not prescribed. Again, nothing is prescribed. There's no qualification that you have to be a trustee. Absolutely anybody can be a trustee.
Thank you very much. Thank you, Karine. Thank you, Eileen. Our contact details are currently up on the screen. You're more than welcome to send us an email. If you, like we said, if you want to request the slides, please do so and leave your email address in the Q&A. Karine, you can just skip that slide for us. Please subscribe to our monthly newsletters. I'm certain some of you are already subscribed. We're currently on our 4th iteration. It went out this week, and all about the responsibilities, duties and reporting lines. Last month's was an AI-focused newsletter, and we're going to keep you updated on any relevant changes to legislation, processes within Trafalgar, etc. throughout these newsletters. Thank you, Karine. And then finally, our last webinar of the year is on the 23rd of November. We'll be sending out those invitations in 2 weeks. Please keep your eyes on your mailboxes and please join us for the last session. But thank you very much for joining us this evening. Thank you very much, Karine. Thank you, Helene, once again. There is an appendix with all the useful links on your screen currently. Please go and click through to those if you need any more information. But thank you very much for joining us, and see you soon.